Welcome. This time we're going to be talking about the Online Safety Bill, which is currently in Parliament. Firstly, some announcements from the government about what this is, how to characterise this. These are tough new internet laws, and they want you to understand that because they wrote it in capital letters on their website. They say that it upholds free speech, and you can take your own view on that. And they say that it will make sure that there is no safe spaces for criminals online. They say that it comes as new plans to support vulnerable people and fight falsities online are launched. Fighting falsity. Somebody on the internet said something, and it was wrong, so they made a bill. This is a quote from Nadine Dorries, the Secretary of State. Our groundbreaking online safety bill will make the UK the safest place to surf the web. It has been significantly strengthened following a lengthy period of engagement with people in politics, wider society, and industry. The safest place to search the web. I'm not personally sure so much whether I question that or question whether it's even a meaningful concept to attempt. But one thing that I am more sure is that it's perfectly possible to make the UK one of the least attractive places to host user-generated content. It's a substantial bill. It has 194 clauses, 14 schedules, and stretches over 225 pages. So now let me take you through them one by one. Okay.
Just play the TikTok,
Firstly, the scope of this. It's targeted at online services, that is, over-the-top services. It's not targeted at internet access providers or transit or that sort of thing. That's not to say that there aren't some things that will impact there. The enforcement mechanisms do include provisions for blocking access to services that are non-compliant, which would be a duty that could be placed upon access providers to block access to certain services. But that's sort of way down in the sort of enforcement end and not the primary focus. The main thing is any services, and mostly it's user-generated content. So what they call user-to-user services, which are defined as any service that enables users to share user-generated content. With a few specific exemptions. So, for example, email is specifically excluded. SMS and MMS are specifically excluded. Pretty much anything where one user can communicate with another user, that service is going to be included. Also, search engines. Most of the things are sort of duplicated for search engines. All the duties are duplicated for search engines. And that means not just, and they call it search services, because that doesn't just mean a search engine like Google or Bing, but also includes anything that searches across an online database or brings multiple things together. So it probably is going to include things like news aggregation services within the scope of search services. And various forms of aggregation engines certainly would be included. It's also got some brought in since the draft bill. This is now the real bill, the one that's actually in the process of being legislated. This now brings forward, or brings back, the provisions for pornographic websites, even if there's no user-generated content on them, specifically porn sites, to do age verification mechanisms. Beyond that, it includes a number of additional duties for Category 1 and Category 2B user-to-user services and Category 2A search services, whatever they might be. So how far does this extend? Well, the idea here is to make the UK safe. And there's a big world out there, so naturally we need to regulate all of it. And so the extent of it is to regulate any such services where there are a significant number of UK users, or where the United Kingdom is the target market for that service, if provided that the service is capable of being used by UK individuals, or that there are reasonable grounds to believe that there is a material risk of significant harm to UK users. And if those tests are met, then wherever you are in the world, you'll be regulated by the UK. Now, one might question whether how much attention the rest of the world is going to pay to this, and it probably depends on your business profile as to whether you are worried about, for example, visiting the UK and being subject to enforcement mechanisms when you do so, or whether you're a substantial business that has got business interests around the world and that essentially could be subject to financial attack through the court system and external enforcement. For others, possibly one of the things that this means is that if you've got an idea that you can sit in the UK and have your content and run your business that's got user-generated content, but it's all hosted in somewhere outside the UK, and you've got payment systems in some other second country outside the UK, and you're incorporated in some third country outside the UK, and that's not going to get you out of it. Because if you live in the UK, they can still come after you. After all, they're regulating all your businesses around the world in all those 3 locations. So the idea is there's no escape. Finally, a note on children. As I take you through the various provisions, you can break them down further by whether or not the service is likely to be accessed by children. And the standard for this is it possible for the children to access the service? Possible. Okay. And then, are there a significant number of children that use the service? Or is it of a kind that is likely to attract a significant number of children? And if it is, then as well as the standard provisions, you will also have the requirements for services likely to be accessed by children, which is another set of similar requirements. All services, whether children-orientated or not, must conduct a children's access assessment to ask yourselves whether or not these tests are met and to record the outcomes of them. If you don't do that children's access assessment, then you shall be deemed to be a site that is likely to be accessed by children and then subject to all the children's protection mechanisms as well. So there's the first thing that all services will have to do, a children's access assessment, and must do that at least every year, and also must do it before making any significant change to their service that might be relevant to the assessment. In other words, relevant to the assessment of whether or not it's likely to attract a significant number of children or does indeed have a significant number of children using it. And anytime you fail to do that, then you automatically become deemed to be a service that's likely to be accessed by children and must also apply the children's measures. A brief overview of the duties for online services containing user-generated content. Firstly, you must conduct a suitable and sufficient online illegal content risk assessment, which means you must ask yourselves, what is the risk of there being illegal content on my service? And you must do that for each kind of priority illegal content. Now, priority illegal content is going to be defined by regulations to be passed by the Secretary of State. And one of the changes between the draft bill and the the bill that's going through Parliament, is that they've actually come out with an initial list on the face of the bill of the prior to legal content, which I'll come to later on. And you are supposed to assess each of those, and you must do so each individually for each separate kind of priority illegal content, as well as a generic assessment of the risk of there being anything else that might be illegal on the service. And again, you must do this before making any significant changes to any aspect of your service's design or operation, scoping around the aspect to be changed. And you must keep it up to date. And you must keep it up to date not only in terms of the law and the new sets of priority legal content that come out, and indeed the changing nature of your service, but also in relation to the risk appetite, if you like, the risk profile that Ofcom describes when it publishes risk profile statements, essentially its tolerance for risk. And of course, you must keep written records of these assessments. And if you don't, there are quite significant monetary and other penalties available. Having done that, you must then take proportionate measures to effectively mitigate and manage the risk of harm to individuals, as identified in the risk assessment. And this means that you must implement systems and processes designed to prevent individuals encountering priority illegal content. That means in advance, that proactive, and to minimize the time that illegal content is present. And you must also have systems and processes to swiftly remove any illegal content once you've been notified of it. Now, we're used to the idea that when you are notified of illegal content on a service that you're hosting, it must be removed expeditiously. And that's still applying to illegal content. But for priority illegal content, we're extending this now to be a duty to prevent it being encountered and to minimize the time in advance. This is a direct reversal, if you like, of the provision in the e-commerce directive that we used to be protected, well, and still are until this passes, protected by, that says that there is no general duty to monitor the content on an online service. And this imposes such a duty by requiring you to prevent that in advance. And this is intended to apply across all aspects of the service. And every element of it must be included. So whether that means your internal policies, your terms of use, your content moderation practices, the user support that you give, the algorithms that you use for selecting and prioritizing or sharing content, any user functionality is there. You must be asking, is that user functionality something that will be making it more likely that people will encounter priority illegal content? And if so, maybe you shouldn't actually be allowing that functionality on your service. Now, I said there, and the children's risk assessments were another thing as well. So these are essentially similar to the illegal content risk assessment. Again, working through each kind of thing one by one to see, is there a risk of this kind of content on my service? But it applies to legal content that is deemed likely to be harmful to children, or to some children. And the regulations will designate priority content harmful to children. I'm afraid, unlike the priority illegal content, we haven't got a list of priority content harmful to children as a starting point. That will come in the future. Again, though, you're going to be required to assess each type of such content separately. And also, not just a separate assessment for each type of content, but also for different categories of children. So a separate assessment for this content and that age group, and this content and that age group, and the first type of content and the first age group, and now the second type of content and the second age group. And and so on and so forth in a ever-expanding matrix. And not just age groups, but also children with certain characteristics or of a certain group. No definitions given for what that means, but is going to refer to children that are deemed vulnerable for one reason or another to some kind of psychological harm, and will likely include things like epileptic children, certainly, or children that have been victims of abuse, certainly, and probably also children who are essentially not straight or not what we now call cisgender, and so forth. And consider all of these things and the potential harms of all of this content. James is trying to ask me a question. Could somebody get him a microphone, please? Over here.
Sorry to interrupt in that great flow of stuff. Are we talking about just user-generated content in this case?
Yes. We're talking about the risk of encountering content from on a surface that covers user-generated content, yes. Now, there are exceptions for specific protected areas of content, specifically news media content. Is that what you're getting at here?
Yeah.
Okay.
And the other one is, do they actually define what user-generated content is?
Yes, and essentially anything that is created or posted by a user, with certain very narrow exceptions for when they have specifically posted the entire copy of an article from a recognized news media, which is specifically excluded. But an excerpt wouldn't be, and a meme based on news media content certainly wouldn't be excluded.
Okay.
Okay, so there's the risk assessments. Be careful. Children's safety duties. Now again, just as you have the illegal content safety duties, then you've got certain safety duties being added for material likely to be harmful to children. And remember, this is for any service that is likely to be accessed by a significant number of children, must do this, regardless of whether it's targeted at children. Systems and processes to protect all children from encountering primary priority content harmful to children. And children of certain ages to be protected from other kinds of content, e.g. by age verification. And the whole age verification thing that first came out in the, the Digital Britain thing in 2011 was that, carried on for like 2 or 3 years before they, without being implemented before they gave up on it, brought it back again a couple of years ago, never implemented that either, and now we're back to it again. And then, of course, duties to set out in your terms and conditions clearly what you are doing in order to protect children, including specifying the use of what you are doing with proactive technology to protect children on the service. And then once you've written things in your terms and conditions, unlike a usual set of terms and conditions, you will then be under a legal duty to comply and to follow the things that you said that you might do in the terms and conditions. So whereas normally a set of terms and conditions you say, and by the way, if you do X and Y, then we might do something as a result. If you're not allowed to put something on the service, then we could cut you off, that sort of thing. You write in your terms and conditions. But whether actually or not you do so is a discretionary matter for you. Well, under this, no, it won't be a discretionary matter anymore. Once you've said that something's not allowed on the service, you must enforce it. Category 1 services have some additional duties, again around terms and conditions, setting out how content that is legal but harmful to adults will be treated. Again, no definitions of that on the face of the bill. Again, the duty to conform to your terms of service in that regard. That is, if you say that, whatever it might be, that you consider to be harmful to adults, I don't know, transphobic material or something, then you must ensure that it doesn't appear on your service because you put it in your terms and conditions. That's no longer discretionary. And a duty where proportionate to have functionality so that adults can limit their access to legal but harmful content, so that they can filter out material that they consider harmful. There are additional duties for Category 1 services to minimize fraudulent advertising. There's a whole section on that I'm not going to go into in any further detail. There's a duty to offer adult users the opportunity to verify their identity. True names. Now, the thing is that this actually is written, says that adult users must have the opportunity to verify their identity. It doesn't actually say that the service must show that verified identity or the verification of that identity on the service. But maybe that will come in a code of practice. We'll see. And finally, Category 1 services will have, actually not finally, these are just a selection, but another one is that Category 1 services will have a duty to report child sexual exploitation and abuse material. We keep changing the name of this to the National Crime Agency. Finally, codes of practice. How are you going to do all this? Ofcom is going to be issuing codes of practice in relation to all the preceding duties. Potentially lots of them, potentially in a lot of detail. The Secretary of State can direct Ofcom to modify a code of practice for reasons of public policy. That means, essentially, they've got complete free rein the Secretary of State got completely free rein to rewrite or insist on a rewrite of a code of practice because they believe it's government policy. There's no limit, really, under that term as to when they could do it, when they could issue such a direction. Now, similarly to the telecom security requirements that many of us have been dealing with, compliance with the code is not precisely a legal requirement. The requirement is to fulfill the duties that I've just described. Compliance with the code is merely the way that you show that you're fulfilling that duty. If you can show that you have followed all the things that are set out in the code, then that guarantees that you have fulfilled the duty by law. So there's a strong incentive for you to do it. And Ofcom and the court must take into account, when assessing whether enforcement measures and penalties, must take any code into account when assessing whether any other measures that you've taken, if you haven't followed the code, but you've done something else instead, and you say, well, that's good enough to satisfy this duty, they must take the code into account. You could argue that in your particular circumstances, the other things that you've done are good enough, but they're going to be looking at the code to see, well, yes, but you haven't done this, so why should we think that's enough? So it's not precisely that you're legally required to follow the code of practice, but in most cases, you'd be pretty brave not to. Fees. So if you're in the scope of any of the things that I've described, you must notify Ofcom declaring all the regulated services that you provide and your qualifying worldwide income, and there's a means of describing what counts as qualifying, but essentially anything related to any of the regulated services that you provide, and supporting evidence as to be set out in regulations to justify that. And then you will be liable for a fee. Because this doesn't come for free, and naturally the valuable service of being regulated by Ofcom for all of this is something that naturally they wish to be paid for. So this is essentially similar to the administrative charging scheme that we have under the Communications Act, where providers pay an administrative charge to Ofcom each year. However, in the administrative charging thing, it's really just a straight according to turnover bands and so forth. We don't know whether this is going to be as simple as that, because there are different categories of services here that might be more or less onerous to regulate, and the cost might be spread evenly across the whole industry according to turnover, or they might be segregated according to certain subsectors of services for which are more expensive. And we don't know the answer to that yet. Nonetheless, essentially it means that yes, you have to notify Ofcom and you have to pay. But Ofcom will be setting out, as with administrative charging, a threshold figure for turnover, below which notifications and fees are not required, and other exemptions, which probably means some categories of services that are technically within the bounds of the scope that's covered, but are not really main target. I imagine that those other exemptions will be to exclude those from the administrative charging. That's just my guess, though. So enforcement provisions. So Ofcom is given powers to demand information from you, to demand a regulator provide and name a senior manager responsible as a fall guy, who will be the one that will be the target of personal liability, to impose skilled persons reports, which is essentially a sort of not quite an audit, but sending in a sort of management consultant type person to investigate your business, to assess your compliance, and to conduct full investigations and to conduct full-on audits. Ofcom can direct providers specifically on how to deal with terrorism and child sexual abuse content. Ofcom powers to enforce compliance include something called confirmation notices, which confirm that you are in breach of the obligations, either for risk assessment or for the safety duties, and give you direct instructions on the steps that you must take to bring yourselves back into compliance. It can mandate the use of proactive technology, such as filtering technology, upload scanning technology, and the like. Fines for non-compliance. There's a whole process you go to before you actually reach a fine, and they're capped at 10% of worldwide turnover, or £18 million, whichever is the greater. Yeah, so if your turnover is under £180 million, then the cap is £18 million. Service interruption and disruption orders are the last thing, are aimed at non-compliant services. Service interruption orders basically order you to essentially shut down or stop providing the service. And service interruption orders and service disruption orders are essentially blocking orders to access providers to block access to your service. And so that's essentially aimed at foreign entities that are essentially saying, no, we're not cooperating with this. Okay, then UK access providers will block access to that service. And finally, criminal liability for senior managers for non-compliance with information notices. So, what does this mean in terms of impact and first steps? Firstly, any business containing an internet-based service containing user-generated content needs to think very seriously about whether you're within the scope of this legislation. Generally speaking, any web or app-based service that contains user-generated content probably will be, unless you can point to some clear exemption. Internal business services are exempt. That is stuff that is only accessed by people within your own company. There are also exemptions, an exemption in there for where user-generated content is just posting of user comments or reviews on provider content, i.e. where someone is running a website and they're the one that's posting the content, and then they allow a comment underneath an article. Potentially that's exempt. And that's kind of crucial to ensure that there isn't massive overreach on this. But it may well not be as protective as it appears, because what level of, if you've got general comments on the things on your website, and you provide something that's just outside the scope of that comment on the article, for example, a forum that includes a general chat channel or something like that, then you've just fallen outside the scope of the exemption. So if you want to, so on the one hand, that exemption is going to be the thing that stops large numbers of websites that really, many ordinary websites from falling within the scope and stop it being, and make it an industry thing rather than an everyone thing. But on the other hand, it's also the provision that is probably the easiest to accidentally fall outside the scope of its protection and basically get you into trouble. And therefore, there's a good case here that you really might want to take legal advice on that, even though this is exactly the clause that is intended to stop everybody needing legal advice about everything. So that's a problem. There are some other limited exemptions in there that apply. I'm not going to go into all the details, but it's very encompassing. Okay, any provider of an internet search service, and remember my definition of internet search went beyond traditional search engines, and of course if you're a provider of pornographic content, then you want to look at those provisions. So, if you fall within anything that sounds like that, expect to need professional legal advice on compliance with this legislation. And expect to need to establish, if you do fall within it, a dedicated compliance team, because the duties are, there's a lot of work and a lot of paperwork that needs to be kept, as well as potentially substantial changes across the organization. But even if there are no changes that are required, you need to document why not. And what this means is that many business customers of UK hosting and services, and if you're including if you're providing essentially, what my ancient and out-of-date terminology would call a leased line to a business that's doing its own hosting. Those customers may well be impacted. If they've got any kind of user-generated content on their service, they really need to think seriously about how this is going to impact their business. And that's why this is making this quite a challenge to have any kind of content, hosting of content that involves user-generated content in the UK, because there's a lot of work to be done here. So before I go into the main changes from the draft bill, does anyone have any questions? That was kind of a trick question, because you should have been asking me, so what's a Category 1 service, Malcolm? Because you never mentioned that. And a Category 1, and the answer to that is that there's two answers to that. One of which is accurate and useless, and the other one of which is helpful but probably wrong. And the helpful but probably wrong is that this means Facebook, Twitter, and YouTube. And the accurate and useless is we don't know. It's going to be defined by functionality and size. But those definitions aren't published. But in principle, this kind of means Facebook and Twitter and YouTube, but what we don't know is how far it's going to extend out beyond those. Yeah? So for example, would this cover eBay and Amazon Marketplace and that sort of thing as a Category 1 service and all those sorts of things? What about other services? Would it be any video upload service? And where would that do? And how far will that extend? We don't know. So the main changes since the draft bill. The new criminal offences, how much time do I have left? Anyone? 4 minutes, okay. In that case, I'm not going to go in detail through these new criminal offences proposed by the Law Commission, because I did speak about these at some length at a previous meeting. But we are going to have a new offence of harmful communications offence, where there is, which will be make it illegal to send a message where there's a real and substantial risk that will cause harm to a likely audience without reasonable excuse. And harm means psychological harm, and it doesn't have to actually affect anyone. And what constitutes a reasonable excuse is a matter for the courts. But if people claim that I've been harmed by this, or somebody might have been harmed by this, that could be a criminal offence. And now remember that when we're talking about removing illegal content, making this illegal means that this is the stuff that you must be able to assess a really quite subjective law like that. There's a new false communications offence, which is actually much more narrowly drafted. Sending a message that you know to be false without reasonable excuse with the intention of causing non-trivial psychological harm or physical harm to a likely audience. Then there's a threatening communications offence. This actually is quite narrowly drafted. You must have the intent or be reckless as to whether the recipient would fear that the threat would be carried out. And then there's, I'm sorry, but this is just going to end up being called the dick pics offence, because that's what it is. Apologies, but that's essentially what that is. One good thing, Section 127 of the Communications Act, the improper use of public electronic communications network, which is the most broadly and vaguely drafted thing that includes covering any message that's grossly offensive or indecent or obscene or of a menacing character, is being repealed as a result of those new offences. So we're getting rid of the idea that it is illegal to send any message or make any posting on the internet that is indecent, which, given the amount of porn on the internet, is actually catching up to the sort of some kind of reality. The only bit of the Communications Act 127 that's being retained is the persistent misuse element of the offence, which was aimed at the sort of heavy breeders, silent calls, those sorts of people. Regulation for people that are actually running porn sites. Don't really have time to get into that. Right now, priority legal content. This is the stuff you're going to have to proactively monitor for and minimize the availability of. There's a schedule of various terrorism-related offenses, including membership of an organization, fundraising, soliciting membership, all that sort of thing. Various child sexual exploitation and abuse offenses. And a list of things that you actually expect to be against the law. And you can read them on the screen there. These are things that are going to be the priority things to minimize and to filter for. How are you going to identify that? I don't know, but... and further, these ones, specifically from those three acts, notice that the racial and religiously aggravated public order offences, which were very controversial at the time they were passed, and publications causing hatred on the grounds of religious and sexual orientation, again, very controversial about whether they were overreaching at the point when they were passed, all covered in the things that you now must be proactively monitoring for. Certain things that Category 1 providers must do as well to protect content of democratic importance. This is what the government is going to be pointing to say that this law actually upholds freedom of speech. It really doesn't. It means that news content from approved news publishing organizations must have special protections. So it's democratically important if Rupert Murdoch has said it. It's not democratically important if you've said it. So anyway, questions, anyone? No? In that case, we're done. Thank you.
Thank you very much, Malcolm.